everyone. Good morning. My name is Josh Blackman, and I'm the president of the Harlan Institute. It's my honor to welcome you to the 2020 Harlan Institute Harlan Institute Ashbrook Virtual Supreme Court competition. This is the 10th annual contest, and I'm so happy to be here back in person. This year, our tournament focuses on the case of New York State Rifle and Pistol Association versus Bruin, a Second Amendment case pending before the Supreme Court. This competition began on the first Monday in October of 2021. More than 30 teams from across the country submitted briefs and made oral presentations. In early February, we held 13 semifinal matches. 2 weeks ago, we held a round of 8, and in March, we hosted the Final Four. After a rigorous process, the finalists were selected. Now, after 2 years on Zoom, we are honored to be back here in person at the Georgetown Supreme Court Institute. My thanks to Irv Goldstein, Debbie Schrager, and Cal Gold for hosting us here at Georgetown. It's very good to be back here in person. Now it's my honor to introduce the finalists. Representing the petitioners will be Campbell Collins and Gabriella Lovins. These students are from Austin, Texas, and they're from a homeschool. And representing the respondents will be Arjun Kishore and Nicole Orlovsky from Greenwich High School in Connecticut. The format for the competition will be familiar. Petitioners have 10 minutes to present arguments. Respondents have 15 minutes to present arguments. And petitioners have 5 minutes of rebuttal. And I'm happy to introduce the judges on our bench. Presiding will be the Honorable Neomi Rao of the U.S. Court of Appeals for the D.C. Circuit. And some time ago, Judge Rao was my law professor at George Mason. The second member of the panel will be Judge Gregory Madge from the U.S. Court of Appeals for the Armed Forces. And the third member of the panel, beaming in by Zoom, will be Judge Stephen Schwartz from the U.S. Court of Federal Claims. And I'll give you a warning, this panel will be very hot, as they say. And without further ado, let's begin. I'll call the court to session. All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention. The court is now sitting. God save the United States and this honorable court.
Okay, New York State Rifle and Pistol Association. We'll now hear from the petitioners.
May we begin?
Yes, please.
Madam Chief Justice, Associate Justices, and may it please the court. My name is Gabriella Lovins, and along with my co-counsel, Campbell Collins, I represent the petitioners, New York State Rifle and Pistol Association, Robert Nash, and Brendan Koch. The state of New York has denied petitioners' applications for concealed carry licenses under the proper cause section of the Sullivan Act. This is unconstitutional.
Would the court benefit from a brief statement of the facts?
Certainly.
Robert Nash and Brendan Koch both applied for unrestricted concealed carry licenses in the state of New York, but both of their applications were denied due to the proper cause requirement of the New York statute, which is not defined in the statute, but in associated case law, it has been defined to mean that citizens must demonstrate a need for self-defense distinguishable from that of the general public in order to receive a license.
The question presented today.
But on that point, and it's clear that your client cannot make that shown, that your client does not have a need other than the need of the general public.
No, Your Honor. So because citizens are required to demonstrate an extraordinary and not an ordinary need for self-defense, this law is unconstitutional because, as this court wrote in Heller, the phrase "the people" in the Second Amendment refers to all people, not an unspecified subset of the population. And the New York statute narrows Second Amendment protections to an unspecified subset of the population who has that extraordinary need for self-defense.
The way the New York law works is takes our right that has a few exceptions but is offered to all the people and turns it into a privilege that you have to earn by showing that you're special in some way, specifically that you have a special sort of danger. But our rights are not limited to people who have a special sort of danger. Now, because this New York law takes the right to carry guns from the general public and therefore infringes on that core right of self-defense, we have to look at this law under strict scrutiny.
And strict scrutiny requires two things. First, the state bears the burden to demonstrate that this law achieves a compelling state interest. And second, the state has to demonstrate that it uses the most necessary and narrowly tailored means possible to achieve that interest.
If we could talk, in your brief, you mentioned that bear in the Second Amendment means something different than keep. So if I accept that distinction, why that bear means to carry outside the home, why would it have to include concealed carry and not just, for instance, open carrying?
Well, Your Honor, it doesn't necessarily include a right specifically to concealed carry, but the history of the right to carry laws in the United States indicate that it does include a right to carry in some format. So because citizens in New York are banned from open carry, New York has stated that that is not allowed. That leaves the only path that they can carry to be concealed. And because
Go ahead, please finish your sentence.
Because ordinary citizens cannot carry in New York, that's what makes this law unconstitutional.
Can we go back to the strict scrutiny standard? I agree that the Second Amendment is a constitutional right, and I agree that this infringes on it, but we don't apply strict scrutiny to every regulation of a fundamental right. So for example, we apply strict scrutiny in the First Amendment if we have a content-based restriction on speech, but we don't apply strict scrutiny if we have a time, place, and manner restriction on free speech. So for example, you can't have a loudspeaker in the middle of the night in a residential neighborhood. Why isn't this more like a time, place, and manner restriction on your right to keep and bear arms, which would be subject to reasonableness rather than strict scrutiny?
The New York law infringes on the core right of self-defense, and Heller decided that it was the core right. Time, manner, and place restrictions are more peripheral matters to the right. They would be similar in this case to regulating what type of gun you can use or what type of ammunition you can use. This law infringes on the core of the Second Amendment in the way content-based restrictions on speech infringe on the core of the First Amendment. So
And how would you define that core? What do you define as being the core of the Second Amendment right?
Heller has told us that the core of the Second Amendment right is being able to keep and bear arms for self-defense.
And specifically, Heller dealt with the keep prong of the Second Amendment, but because keep and bear are placed on equal footing within the text, that means that bear is also included within that core. There are accessory Second Amendment rights like the ability to carry semi-automatic weapons or the ability to carry certain types of ammunition, and those would fall under intermediate scrutiny. But because New York prevents citizens from carrying these weapons, and specifically carrying handguns at all, that is why this infringes on the core constitutional right and implicates strict scrutiny.
Can you respond to the respondent's argument about self-defense, which is, well, wait a minute. If what you're saying is you need to carry guns for self-defense, but we live in an area where we have police and we have statistics that show that it's generally safe to be about and that the police can take care of us and the government can provide for protection, to what extent do we have to take into account the real need for self-defense as opposed to merely just your client's perception that they would like to have their own form of self-defense?
You never need to have a special need to exercise your constitutional rights. We don't let you have freedom of speech because you have a specific need to say something, and you don't get your Second Amendment rights because you have a special need for self-defense. The right belongs to the people because a need for self-defense can't be predicted and can arise at any moment.
Additionally,
How does that intersect with laws that, for instance, prohibit firearms to people who are mentally ill or who have other conditions? How does your view intersect with that?
well, Your Honor, those operate from the opposite direction. New York has stated with this gun regulation that all citizens do not have a right to self-defense until it is granted back to them, until they have justified it based on their need. However, restrictions on specific small groups of people, such as felons or the mentally ill, to carry weapons operates from the opposite assumption that everyone has a right, but it can be limited in certain circumstances.
But aren't those people also part of the people in the Second Amendment?
Yes, Your Honor. However, there are certain ways that you can lose a Second Amendment right, but you do not have to earn a Second Amendment right. So because they operate from the opposite direction, because they don't turn a right into a privilege, they are constitutional. And additionally, they would likely pass strict scrutiny, which this law does not.
Counsel, could we go back to your previous argument about keep and bear being on the same footing? You know, in looking at Heller, Heller only decided the keep issue, and there was a lot of historical sources that were cited by Heller on the keeping issue, and I'm just wondering, does that decision really help you on saying that keep and bear are on the same footing? Because after all, when we decided that case, we didn't really decide it for both keep and bear. We focused on keep, suggesting to me that, you know, maybe we have to look at separate kinds of historical data and information on the bear issue.
The focus was on keep and Heller, but it didn't ignore bear, and it did specifically say that they are on the same footing. Furthermore, when we look at the Second Amendment, we see the prefatory clause and the operative clause. The operative clause contains our right to keep and bear arms, and it doesn't treat keep and bear differently. It's not the right to keep arms and sometimes bear them. It's the right to keep and bear them.
Additionally, Heller looked at historical precedent and indicated that the Second Amendment right is drawn from English historical precedent, including the English Bill of Rights, which protected the right of English Protestant citizens specifically to carry weapons for self-defense. So that right was extended to all different religions with the Second Amendment, but that same tradition of being able to bear arms is present in the historical sources that we do have.
Can I ask you a hypothetical? Could, for example, this court pass a rule that prohibited litigants from bringing weapons into court during court session? For example, I don't know if any of you are armed, but maybe we don't want the litigants sort of chills the bench a little bit. When the counsel have guns, would it be constitutional for us to just simply say, unless you've got a need, you can't bring a gun into a courtroom?
That seems like it likely could fall under a sensitive place restriction, and sensitive places are specific locations where no one, regardless of your license status, may bring a gun.
We certainly have police officers in the courts, they have guns.
Yes, Your Honor, police officers in sensitive places are treated a little bit differently than an average citizen. And Heller has decided sensitive places are legal. But the difference between a sensitive place law and this law is that it is a specific location where no one can bring a gun, rather than turning giving a person individualized sensitive places. For example, one petitioner may carry his gun on the road to his workplace while the other cannot. That makes that particular road a sensitive place for one of those petitioners, but not the other. So while sensitive places are legal, it's not legal to make individualized sensitive places.
Because those types of individualized sensitive places create, in fact, sensitive people, which is unconstitutional because, as the court found in Heller, the Second Amendment applies to all people, not an unspecified subset.
I see we are out of time.
I have another question, and perhaps Justice Schwartz has one as well, but I'm wondering if your argument would allow any type of gun licensing. Under your reasoning, would it be permissible for a state to require licensing at all?
Absolutely.
For handguns? Because that is a kind of, if you were to analogize to the First Amendment context, it is a kind of prior restraint, right? It restrains your ability to keep and bear arms if you have to seek a license. And so I'm wondering if your logic would prevent state licensing of firearms.
State licensing would not be prevented under this law or under our position. What would be prevented is shall issue state licensing regimes. We need may issue and, excuse me, I have that backwards. We need may issue.
We have may issue in the state of New York, but shall issue is only constitutional for two reasons. First, because the statute in New York allows too much discretion of licensing officers. They are in control of who receives a weapon. And additionally, because the statute has that proper cause requirement that requires a need, which is still unconstitutional because it prevents ordinary citizens from receiving a gun license.
Citizens should be able to look at how to get a license and see if they meet the requirements or have the ability to meet the requirements, such as, okay, I don't have a mental illness, I'm not a felon, but I have to take a training course to get this gun license.
And Heller recognized that preventing states from banning certain types of weapons is unconstitutional, but that does still leave many licensing options for those states.
Let me see if Justice Schwartz has any questions.
Oh, thank you, Madam Chief Justice. I've got, I think, 3 specific questions that weren't covered as far as I could hear by your questions. So one is about the historical context. Counsel, you've done a good job talking about some of the history that's relevant to the Second Amendment, but you didn't mention this 1836 Massachusetts statute that respondent says required, quote, reasonable cause to fear an assault or other injury, et cetera, as a condition for bearing arms. How do you get around that as a historical precedent for requiring some kind of individualized concern before you can exercise a Second Amendment right?
Well, Your Honor, those laws were different from this law. First of all, we have to look at what types of guns were allowed at that time. Second, we have to look at what were the types of self-defense that were sufficient to get a license. For example, could you say, I have a fear that I will require self-defense in a time that I cannot predict. If that was allowed under this law, which is a little unclear, this law would be constitutional because anyone could have a need for self-defense, and therefore the general public is able to get a gun license or be permitted to carry a gun under that law.
Additionally, there's another complication in historical sources because the first open carry ban did not occur until 1872 in Texas. So before that time, concealed carry regulations, even very strict concealed carry regulations, would be more likely to be constitutional because open carry was still allowed and citizens still had a pathway in which to carry.
Second question, you went back and forth with the panel about the kinds of gun bearing restrictions that Heller seemed to countenance, but the respondent had an interesting point that bears not just on what restrictions are permissible, but on the standard of review, because Heller mentioned a presumption of lawfulness, or that some laws are presumed to be lawful, which seems inconsistent with your argument that that strict scrutiny applies. How do you respond to that?
Heller mentioned 4 types of gun laws that are presumptively lawful: bans on felons carrying guns, bans on the mentally ill carrying guns, commercial sales laws, and sensitive places. This law is none of those, as this law takes the right to keep and bear arms for self-defense from the general public. So their argument for strict scrutiny, for intermediate scrutiny, on that basis is based on a misreading of Heller.
And the third and last question, thank you very much, goes to the compelling state interest point. So you've made the point that these laws are not necessary to achieve a compelling state interest and so on, but ordinarily we're fairly deferential to the decisions of legislatures and certainly of state legislatures in deciding what needs are compelling and what the factual support is for whether particular measures further those interests. Why shouldn't we defer to New York in this case?
Yes, Your Honor, that's for 2 reasons. First, because New York has not met their burden to demonstrate that this law actually achieves the compelling state interest of public safety that it sets out to. And second, because no government interest is so compelling that it allows the legislature to remove a core constitutional right, which is what the New York legislature has done in this case. Some sort of tailoring is required. New York has to demonstrate that there are no less restrictive means that they could use to create the same effect, which they have not done. Instead, they've created a blanket ban with a few exceptions, which turns a right into a privilege.
And DC v. Heller says specifically, the enshrinement of constitutional rights necessarily takes certain policy choices off the table. This policy choice needs to be taken off the table because it directly infringes on the ordinary citizen's right to bear arms for self-defense.
Thank you very much.
Thank you, nothing further.
We pray that this court will reverse the judgment of the lower court, render a judgment declaring the New York statute unconstitutional, and enjoin enforcement of the statute against petitioners.
Now hear from respondents. Please begin when you're ready.
Madam Chief Justice, and may it please the court, the New York law should be upheld because proper cause requirements are constitutional. We would like to add a few matters to the facts of the case presented by petitioners. Most importantly, that the petitioners had the ability to appeal their permit decisions, and both did so. Both permit decisions were upheld by Justice Richard McNally in November of 2016 and 2018, respectively. New York State has a may issue gun permit regime in which, for citizens to acquire a license, two standards have to be met. First of all, they have to meet typical requirements in most states, such as not being mentally well as not being a felon. But second of all, they need to have an officer approve of their decision after they prove that they have a heightened need for self-defense above that of the general public in people in a similar situation. We'll now move into outline our case and then into a review standard. Our case has two prongs. First of all, the government's interest in promoting public safety, and second of all, federalism. In terms of the review standard, we believe that intermediate scrutiny should be applied for a few reasons. First of all is the historical backing. Historically, the Second Amendment has almost always had the government regulated in some manner. All the way back to the early 14th century, we cite orders by Edward I as the first example. And then throughout English common law, the founding of the country, and early American law, there are examples of regulations. Past that, we also see that, while not binding to the Supreme Court, appellate courts historically have applied intermediate scrutiny because of the incredibly important interest in promoting public safety. Cases such as Gold v. Morgan and Kuchelski versus Kaseki show this.
Let me ask you a question about that public safety rationale. I mean, so one of the main arguments in your briefs is that that the government protects public safety in public. And but what if the government is failing to do that? Right? What if the government is failing in its obligation to keep the public safe? And then the state law is denying people the right to bear arms. I mean, so what should citizens do when the government is failing in its obligations?
Well, Your Honor, the Second Amendment was built to allow citizens to protect themselves, but if the law itself is viewed as failing, we believe that the legislative process is a more effective way to combat this. And there are two reasons. First of all, this is historically backed by precedent. Supreme Court precedent such as Holder versus Humanitarian County holds that issues such as public safety generally defer to the legislature. But second of all, we believe that this would go further, that broadening the Second Amendment right to this extent would actually further the danger in public safety. You can look to the recent New York subway attack as an example of this. In that situation, there were no armed citizens within the subway, which prevented crossfire and other citizens from being harmed. However, we would contend that if the citizens within that smoke-filled subway car were armed with weapons, it would make the situation worse. We cite in our brief a multitude of studies and examples of how citizens being armed with weapons more often than not actually ends up in them harming innocent civilians rather than reducing crime altogether.
How should we think about those empirical studies, right? I mean, what role do empirical studies about public safety and carrying firearms today bear on how we should understand the Second Amendment? I mean, is that even relevant to the legal question before us?
Yes, Your Honor. It is relevant to the legality of this because we've seen in other cases such as Gold v. Morgan, the use of statistics. However, in the case where there are conflicting statistics, such as if there are statistics that could be used to support either side of the argument, in Gold v. Morgan, Antonin Scalia wrote that in this case, their deference should be given to the legislature, to the states. So this goes to the second prong of our argument, which is federalism and that deference to the legislature to protect the states' rights to legislate on an issue such as this.
But before we move on to that, suppose that we agree with what your brief says, which is that right now it's safer to regulate guns and that the police do a good job of providing protection. But let's suppose things change. Let's suppose, for example, that the defund the police movement catches on and New York gets rid of its police officers altogether. Would this statute then become unconstitutional? I mean, in other words, I'm a little concerned, my concern just specifically is that if we rely on statistics and data taken at a particular time, then a law might be constitutional one moment and then unconstitutional at another moment and vice versa.
So, Your Honor, we would propose two responses to this. First of all, we do think that if that were the case and police were removed altogether, that would significantly alter the context of this law. We cite in our case the expectation of safety. In New York police, the policing power of New York State, protecting the safety, welfare, and health of the citizens, this falls under 3 of the 4 policing powers of the state. But also, Your Honor, we think that this law, as demonstrated, happens in a world where policing powers exist. So basically, the expectation of safety is relevant. So it's hard to speak exactly what would happen if police were removed, but we think it is incredibly relevant that police do exist in this world, and that does play an impact. And as Holder found, when there is a question of statistics, we believe that this prevails constitutionally. But on top of that, the use of statistics itself, almost always the Supreme Court has established, leads to deference to the legislative branch.
Counsel, let me also ask about your argument that the government provides self-defense. Suppose the government decided to issue a newspaper and then said, look, you know, we really are wasting a lot of resources with private newspapers. If the government can provide the newspaper, we don't. I know there's a freedom of press and all, but you don't really need to have your own press because the government is providing a government-provided newspaper. And it's, you know, if that changes, then you can publish your own newspapers. But as long as the government has a newspaper, you don't need a right. I mean, wouldn't we say that that's ridiculous?
But Your Honor, there's 2 reasons why I believe that that is a slightly different scenario than the Second Amendment. And first of all is the long history. Built within the Second Amendment, we believe, is this principle of government regulation. We cite numerous amount of laws that hold this idea, and even proper cause requirements, which are over nearly 200 years old at this point. But then the second aspect is that the Second Amendment right in the exercise of the Second Amendment is not impeded entirely by this law. We, of course, see that the petitioners are able to carry within their home, they're able to carry within their car under a separate licensing regime, and that the petitioners can also carry in off-country and backroad areas. So for 2 respects, the long history of Second Amendment regulations, as well as the fact that it's not impeded entirely, we think this is slightly separate. On top of that, I'd like to add that this is something brought up by the petitioners, but the First Amendment and Second Amendment should be viewed within slightly separate lenses. Of course, First Amendment examples of regulation, such as parade permits, show that there is a government ability to regulate. However, the Second Amendment impact on public safety is far greater than any negative impact that First Amendment exercise might have.
So, so you've made a lot of arguments about deference to state legislatures in terms of regulating firearms. Do you think this court was mistaken when it incorporated the Second Amendment?
No, Your Honor, we don't necessarily think the court was mistaken in this, given that a lot of fundamental rights at this point have been incorporated through selective incorporation. And this actually does give more latitude to the states because it's incorporated against the states. You're getting a level of individual right, but also a level of state power or separation instead of just having the fundamental rights at the national level.
And I'd also like to add to that this discretion, we do believe that McDonald correctly incorporated the Second Amendment, but it's also relevant to understand that discretion is important in the public safety implication. Of course, this was before Heller, but Prince v. US showed that discretion in the Second Amendment has real impacts within individual communities. So this idea of discretion goes to an actual policy end, where it allows legislators to more closely tailor their means to their cities. We note that many of the states that have regimes similar to New York are highly dense states that have, tight places such as subways that have a much greater public safety implication if weapons were to be within them.
Furthermore, in Prince v. US, we see that a local police commissioner, or rather a chief law enforcement officer, made the decision not to do background checks within his state. So the flip side of that, the 180 degrees, would be an officer in New York deciding to do background checks or to do this examination of proper cause. And we upheld it in Prince, so we should be able to uphold the opposite version of that in giving states discretion to legislate the way they see fit on gun rights, especially because states have different situations and they know best how to legislate on that.
So can I ask you about the Heller decision, and specifically Heller's description of sensitive places as being one area where gun regulation would be permitted? It kind of sounds to me like you're saying the great outdoors anywhere is a sensitive place. Doesn't that kind of negate this whole idea that sensitive places is an exception?
Well, Your Honor, I would respectfully say that we are contending that New York in general is not falling under the sensitive places. We contend that a sensitive place restriction is slightly different from the regulations we're offering here. So sensitive places, as you correctly state, in Heller were identified as singular, unique locations, such as a courtroom or a small school, where in this situation, we're saying New York as a diverse state with multiple different cities all have different regulations. So for example, bearing within all of New York City, this does not make all of New York City a sensitive place. However, it does uphold the safety of New York City. So respectfully, we would contend that this is an alternate in a regulation form that can coexist with the sensitive places regulations that were set up in Heller.
I was interested in the argument in your brief about the link between the First Amendment and the Second Amendment. One of the arguments you make is that that public safety is important for people to exercise their First Amendment rights. So curtailing people's Second Amendment rights might allow them to better exercise their First Amendment rights. And I was trying to think if there were any other examples in which we have said a restriction on one fundamental right is necessary to further other fundamental rights. And I'm wondering if you have any examples of that type of reasoning where we're sort of trading off fundamental rights against each other.
Well, Your Honor, I would say in general that's in many ways how fundamental rights work, and Second Amendment regulations in general function by regulating one fundamental right in terms of another fundamental right, the most fundamental right, the right to life. So we think in that respect, we see that Second Amendment regulations in that sense are regulating a fundamental right to protect another fundamental right. So we think that that's somewhat of an analogous situation, but once again, we'd like to state that the Second Amendment right is unique in the impacts that it has on public safety, where no other fundamental right is as dangerous to public safety or the exercise of other fundamental rights or rights in general as the Second Amendment can be.
Justice Schwartz, do you have any questions?
Yes, counsel. So I'm curious about the standard of review. You've put a lot of weight on this phrase presumptively lawful in Heller, but as I look at the categories that Heller's talking about, the Heller court was talking about situations where the government is acting in its capacity as a proprietor, or where it's where it's licensing commercial activity, where ordinarily rational basis review applies, or where the people who are supposedly being denied their Second Amendment rights actually have due process protections before the rights are taken away. So given that those examples are distinguishable in those kinds of ways, how do you get to the point that the residue of the Second Amendment is still reviewed by something other than strict scrutiny?
Yes, Your Honor. So the reason we contend that we should use intermediate scrutiny is, as you mentioned, the incompatibility, and also because of the fact that it allows the state government a little bit more deference in legislating on the issue, and because the government's compelling state interest that is also necessary in the intermediate scrutiny standard is so strong, we believe that we easily clear that barrier. And if you don't buy that argument, however, and you would go with strict scrutiny, we believe again that the government's interest is so strong that it clears that barrier as well. And we would use the fact that the least restrictive means required under strict scrutiny is achieved, because the second prong is the least restrictive means to achieve the same compelling government interest. And the state of New York has found that there's no other way to achieve the same level of compelling government interest in public safety and saving lives as in using this specific regime, the May issue regime.
And Your Honor, I'd also like to add one more thing to this point, which is that we're not saying Heller solely sets up intermediate scrutiny or presumptively lawful is the only reason why intermediate scrutiny exists. What we're contending is that because using a combination of this idea of presumptively lawful as well as this long history, as Young v. Hawaii notes, over 700 history of common law and American law regulating the right to bear arms, we're contending that the government should have a higher latitude in regulating the Second Amendment. So while there are the presumptively lawful gun regulations set up in Heller are slightly different, we believe that it falls in line with this long history and precedent that the state has in regulating the Second Amendment right. And for that reason, we believe that there should be a less restrictive or a less restrictive standard of review than strict scrutiny applied to this case.
Your Honor, I see my time is last. May I add something to the question? Thank you. Furthermore, we see that New York is unique in the differentiated areas of its state. So there are rural areas, but there's also a large urban area that we see in terms of other states that also have may-issue regimes. There's a subway system. These areas have a need for the government to regulate more because the public safety risks are higher in that area, as we saw in that subway car. If someone in that subway car or multiple people in that subway car all had these permits, if this law was struck down, everyone in that subway car is at greater risk.
One final question about the historical evidence. So there are different categories of historical evidence that you and petitioners have referred to. The medieval evidence strikes me as hard to take out of its medieval feudal context, and some of the later evidence from state laws strikes me as hard to separate from, one, it's after the Bill of Rights, two, it's before incorporation, so hard to say how much weight to put on that. So what do you have that specifically rebuts the founding area view of the importance of individual self-defense as a fundamental right?
Your Honor, we have the 10th Amendment. We have the system of federalism that states that states need to also have this power to make sure that there's no tyranny, especially by the federal government, as the founders intended. So we've seen this level of deference right from the founding era in letting states legislate to this, and in a way that doesn't fully extinguish the rights as their petitioners contend, but rather regulates them in that way. And furthermore, we have the historical context of this law being in place since 1911, and as gun issuing regimes go, this is relatively long-standing, been in place for about 111 years now. So we see that this has this historical context, this tradition of being in place in New York State specifically for quite a while.
And Your Honor, we would also add that changes in society change the expectation of safety while also making weapons much more dangerous than they were at the time of the founding. As we know in a brief, multiple security, such as the police powers of the state and security systems, as well as guns getting more dangerous, all mean that the Second Amendment right, the need for self-defense in public is greatly reduced, while the impact that it has on public safety and chilling other fundamental rights is greatly increased. So for that reason, we think that this regime is in line with that founding historical era way of thinking.
Nothing more from me.
Thank you, and we pray that this court upholds the law.
Thank you.
This time.
Madam Chief Justice, Associate Justices, and may it please the court.
We respond to 3 arguments made by the respondents. First, that they conflate public safety with the right to self-defense. Second, they ignore the second prong of both intermediate and strict scrutiny, the tailoring requirement, And finally, that the Second Amendment is not a second-class right. First, respondents conflate the right to public safety with the right to self-defense. Self-defense is what the court has interpreted the Second Amendment to protect. And no matter how good the police system is, no matter how many resources the state has to protect citizens, that does not negate citizens' right to self-defense and to bear their own weapons for self-defense. And because the court in Heller indicated that handguns are the quintessential self-defense weapon, and that no matter what other avenues of self-defense citizens have available to them, handguns cannot be completely removed from the table. The New York statute is unconstitutional.
Looking at scrutiny, whether it's intermediate or strict scrutiny, we still hold that strict scrutiny is the proper level of review. And while we are not ready to concede that this law does actually increase public safety, we'd like to focus on the second prong, which is vastly more important, and that's the narrowly tailored prong. For strict scrutiny, the law must be necessary and narrowly tailored. This law is not necessary, nor is it narrowly tailored. More than 40 other states have completely different laws that do not infringe upon our Second Amendment rights, and it's not the Wild West there. Now, narrowly tailored, this law is not tailored. It takes the right away from all of the people, instead of targeting a specific group of people likely to go out and commit gun violence. When we look at intermediate scrutiny, the court last week in City of Austin v. Reagan National Advertising said that intermediate scrutiny is narrowly tailored with a significant government interest. Once again, this law is not tailored because it targets the people instead of a specific group of people likely to go out and commit gun violence.
So is it your view that any regulation that targeted all of the people would be unconstitutional?
Any regulation that took a right away from the majority of the people is most likely unconstitutional.
It's specifically the way that this particular law operates, that it forces the people to justify their need for self-defense in order to exercise a core constitutional right. So while there are and could be many different constitutional limits on the Second Amendment that do apply to all the people, such as a training requirement or a requirement to show proficiency, this specific law, because of the way it operates and the way it forces citizens to justify a Second Amendment right based on need, is unconstitutional. And similar laws also would be unconstitutional. Third and finally, the Second Amendment isn't a second-class right. So it should not be treated differently, as it is it has equal weight within the Constitution. Different constitutional rights do not decrease each other. So even though public safety may increase the First Amendment, this still does not give the government the power to remove individuals' Second Amendment rights.
It goes back to that quote from Heller: "The enshrinement of constitutional rights necessarily takes certain policy choices off the table." Once again, the First Amendment right is not a more important right than the Second Amendment right, or a right that you have all the time while you just have the Second Amendment right some of the time. You have both rights all of the time.
Counsel, can I just ask one point of clarification between your two briefs? In your footnotes, you both cite, both you and the respondents, cite studies which seem to contradict each other on the public safety question about open carry laws. What do we do with that where there are contradictory studies? Respondents seem to suggest, well, if there turns on statistics like that, we really ought to just defer to the legislature.
Yes, Your Honor. It really comes down to that second prong of both strict scrutiny tests, that there is a tailoring requirement. So even if this law achieves the public interest, because this right is contained within the Second Amendment, because it's protected by the Second Amendment, it still does not allow the government to remove the right even for a compelling state interest. There is no state interest so compelling that it allows the state to remove a constitutional right.
As far as the studies go, as you mentioned, there is a very hard contrast. So at very best, this can't be proven whether this law actually achieves public safety. I see my time is up. May I finish?
Yes.
So because of the contradiction, we cannot know if this law truly does improve public safety. At worst, for respondents, we have a study specifically dealing with the Sullivan Act that came out in February that said this does not lead to a reduction in homicide. So the studies are inconclusive, if not showing that this law doesn't make a good difference on public safety.
We pray this court will grant the petitioner's appeal.
Thank you. The case is submitted.
Did you want to ask?
Oh, sorry, Justice Schwartz, did you have any?
No, nothing further.
Thank you, Your Honor.
All right. All rise. Court will be in recess for deliberations. And that means you guys. All right. Congratulations, all of you. The prevailing team is Petitioner. Congratulations. And the best oralist is Campbell. So congratulations to you. We are so proud of you. This was a very hard decision. Teams were evenly matched. But we just want to say this was such a strong competition. And thank you so much. I know the judge would like some feedback to give to you. But congratulations to you very well.
Well, I guess I'll just start by saying, both teams did such a great job. You know, I read your briefs, that you're able to write such clear and logical and cogent briefs in high school is really a testament to all the hard work you've put into things. I see many briefs of varying quality in my job, and I can say you guys have really done a nice job in the writing. And the oral arguments were also very strong. This is a very difficult thing to do, to stand up and to have learned so much about a particular case and about the law, and then to take all of our questions, you know, that are ranging over a whole number of cases and the history and empirical evidence and what are the implications of your view in one place for what might happen to the law in another place. I mean, these are all very difficult types of questions to grapple with, and you, all four of you, did a really excellent job. So it was a hard decision. I think, Campbell, we just thought that you were especially good, at, like being on your feet and pivoting and answering all of these different questions, and really grappling with some of the things that we threw at you. So congratulations.
Well, I'm just really impressed, and I don't think we have to say these are good briefs for people in high school. These are just good briefs, and your arguments were excellent. And, I'm just really impressed at how clearly all of you speak, and how clearly all of you write, and how responsive you were to our questions. And, when I think of good oral advocacy, I try to think of, different points that, I might convey. And one is to be extraordinarily clear in your presentation and what it is you want to convey. And I thought, Arjan, you were just really perfect in that response. Every sentence you said made sense. You were right. You were clear. I could understand everything that you were saying. And I thought, I'm sorry, I forgot your name, Nicole. Nicole, another thing that I think is extremely important is working hard to get people to understand a difficult point. And I thought especially how you drew connections between different cases, try to explain these points. You were looking us in the eye and trying to get us to understand. I thought that was really very good. And Gabriella, I thought you were very sensitive to the concerns of the bench, as opposed to necessarily just the direct question, like why are we asking that question? And I thought in a couple of places you took a step back after saying yes or no to explain what it was about your answer that would address our concerns. And Campbell, I thought you were very, very much on point on every topic. I thought your answers were very concise and extremely responsive. I think one rule at moot courts is that the judges tend to ask questions just to kind of press people and challenge them. And my law clerk might differ, but in actual cases, I try to reserve questions for things I don't know the answer to. And the reason I ask the question is I really don't know the answer, and I really don't want counsel to give me an answer. And if I don't get an answer, that's a really bad situation. And so I thought you were very responsive to those questions. Let me also just say one thing about your briefs. A lot of briefs we get are overly long and full of fluff, and your briefs were super concise on both sides. So this was a very impressive exercise. I want to congratulate all of you for getting to this stage. Justice Schwartz?
So impressed with all four of you. I mean, if all of my advocates in front of me sounded like all of you, and if all the briefs were read like these, that would be kind of a fine state of affairs, really, because you were all to the point. You were responsive to the questions. You were, you lined up your authority in a clear way and used it to support your arguments. And in the clear ways, you listened to the question and answered it without trying to fight the judge. It's really impressive, and you can all be very proud, and you can all go on to, I'm sure, impressive things having developed these foundations. It was harder for me to tell about the kind of oral presentation because I don't have that great a view of any of you, but so I won't give anything individualized on that. One thing about the briefs I'll say is that I once lost a moot court myself because the judges didn't think that my team's brief kind of followed the style and formatting that they were used to. It didn't kind of look and feel like what a brief often looks like. I thought the petitioners did an especially good job of doing a mock-up of what a brief looks like. So they picked a good typeface. They did their blue booking very well. They did their spacing very well. They did their the bolding of headings well, and the nesting of headings well. The use of inline citations and quotations from the authorities was basically what you would expect from a solid brief. And so those kinds of physical touches combined with just an overall well-organized, tight, well-reasoned argument kind of put this brief over the top for me.
All right.
Congratulations to both.
And let me say a few words about behind the bench. I'll send over here. I've now judged you, I think, for 4 rounds. I judge you at the semifinals. I judge you at the round of 8. Don't call it the final 4 because we'll get sued by the NCAA. The round of 4, and I've judged you here. And what I've seen is progress. One of the most important lessons you should take from this experience or any other is learning from your experiences to do better next time. You did improve from the first round to the second round to the third round to up here. I saw the improvement. I saw questions that I asked you 3 months ago that Justice Maggs and Justice Brown asked you, and you nailed in the first shot because you've been there, right? I've seen how you improve your rapport from one partner to the next, how you do this very smooth handoff. It's not usual, law schools don't do this, but I think they have a very good smooth rapport to hand off one to the next. I've seen your demeanor, where you stand at attention, you keep your hands on the podium, you keep your voice flat, right? You don't get excited, you don't get emotional, right? You give a very a sober delivery. And the 4 of you have comported yourselves as well as any law student you'll ever see in a moot court competition. You could walk into Georgetown Law Center 5 feet away tomorrow and go compete in a moot court competition, right? You have such bright futures ahead of you. I am so excited to see where you'll be in 4 or 5 years. I hope you come back and tell me. But more importantly, the reason why I do this, why the Harlan Institute believes in this mission, is we have this crisis of civic affairs. Students don't know about the Constitution. They don't know about the court. They simply just don't know about these things. They think they're totally wrong. You are the exception to that rule. You are having eloquent, passionate, informed debates about gun control, not an easy issue to talk about. And you brought to it rigor and discipline and candor. When your position is not strong, you told the judges, then you pivoted to a strength. So I have hope that the 4 of you and all the other dozens and dozens of people who've been through this competition can bring with them this sort of insight and passion for the law and just make our republic that much stronger for the future. And this is one of the highlights of my year. So I'm so thrilled to be back here with my good friends on the bench and these brilliant young minds. And I hope next year we'll have even stronger competitions to play again. So thank you so much. All right, I think we are at a close, so I will say the court is now in recess. You come up, we'll take some pictures. You can shake the judge's hand, but congratulations, everybody. Judge Brown.